A police officer knocks on your door. You let them in without asking questions. They walk through your bedroom, your closet, your desk drawers. Nothing happens to you. No arrest. No charges, just a search. Most people think this is fine. They say, if you have nothing to hide, a search shouldn't bother you. But this reasoning confuses two very different things. Privacy is not the same as secrecy. The Fourth Amendment doesn't protect secrets. It protects something more basic, the principle that your body and your property shouldn't be invaded without a legitimate reason, proven in advance to a neutral authority. Here's what the amendment actually says. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be infringed. That word, unreasonable, is doing all the work. The founders weren't opposed to searches. They were opposed to searches without rules. During the colonial period, British officers could show up with general warrants that gave them permission to search almost anywhere, looking for almost anything, whenever they felt like it. These weren't targeted operations. They were fishing expeditions designed to intimidate and control. The Fourth Amendment was built to stop that. So what does it actually protect? First, it protects you from being seized. A seizure happens the moment a reasonable person would not feel free to leave. A traffic stop is a seizure. A conversation with a cop on the street where you don't think you can walk away is a seizure. An arrest is a seizure. This matters because you have rights the moment you're seized, not after you're arrested. Second, the amendment creates a threshold. Before an officer can search you or your property, they need probable cause, not a hunch, not a pattern, not a suspicion. Probable cause means specific, articulable facts that would lead a reasonable person to believe a crime has occurred or evidence of a crime is present. This is a high bar, and it exists for a reason. Third, the amendment usually requires a warrant. This is a document from a judge saying an officer has shown probable cause and now has permission to search a specific place for specific things. The warrant has to name what they're looking for and where they'll look. It can't be vague. It can't be search the whole house. This requirement puts a judge, someone outside the police department, someone with no stake in the investigation, between the government and your rights. But warrants aren't always required. If you consent to a search, they can search without one. If someone is committing a crime right in front of an officer, a gun visible on the front seat, they don't need a warrant to seize it. And searches that happen during a lawful arrest fall into their own category with specific rules. Your home gets special treatment. Courts have recognized that homes deserve the highest level of Fourth Amendment protection. This includes not just the house itself, but the curtilage, the property immediately surrounding it, because the colonial era abuses centered on home invasions. Modern life has stretched these principles thin. Your cell phone holds more information than a house ever could. Location data tracked by GPS. Emails stored in the cloud. Courts are still working out how old rules apply to new technology, and the answers aren't settled yet. When the Fourth Amendment is violated, evidence usually can't be used in court. That's called the exclusionary rule, but it's not a perfect remedy. It only works if the violation makes it to trial, and it doesn't compensate you for the invasion itself. The Fourth Amendment exists because power without limits becomes oppressive. It's not about hiding anything. It's about keeping government searches tethered to reason, to evidence, and to the judgment of someone outside the machinery of law enforcement itself.